Section D Attachment. Count 142 U.S.C. 1983 14th Amendment Due Process, Deprivation of Property/Housing Interest Without Due Process. Plaintiff incorporates all factual statements, stated below. 1. Beginning in or about 2020. And continuing thereafter. Defendant Chad Gray initiated interference with plaintiff's landlords in an effort to remove plaintiff from housing. And his conduct formed part of a continuing course of harassment and destabilization against plaintiff that has persisted to date. A. Plaintiff's residence at or about 2020 North College Avenue, Fort Collins, Colorado, where plaintiff was abruptly required to leave after threats from Chad Gray to bulldoze down a building if the plaintiff did not leave. B. After relocating plaintiff's residence at or about Willix Lane, where plaintiff was again forced to leave following Gray's continued interference by threatening the landlord with fines exceeding $10,000 if the landlord did not file eviction notice against the plaintiff, and C. Plaintiff's later residence at or about 12908 Palomino Place, Wellington, Colorado, where Gray again attempted interference threatening in emails to the plaintiff's landlord, but the landlord refused to displace the plaintiff. As a result of Gray's housing interference, plaintiff's ability to maintain stable housing was disrupted, and plaintiff's right to continue residing at housing plaintiff was legally entitled to occupy was repeatedly undermined. 2. In early 2020, defendant Chad Gray initiated interference with plaintiff's housing by contacting the landlord of the shared residence and asserting complaints designed to have plaintiff removed. Gray represented to the landlord that plaintiff should no longer be permitted to remain in the home, even though plaintiff had violated no lease terms and no lawful basis for removal existed. 3. As a direct result of Gray's communications, the landlord abruptly informed plaintiff that he had to leave the residence. Plaintiff was not served with any written notice, was not given an opportunity to discuss or dispute the claims made by Gray, and was not afforded any of the procedural protections required before terminating a lawful tenancy. 4. Following Gray's interference, plaintiff was effectively excluded from the property and prevented from continuing to reside there. Plaintiff lost access to personal belongings and experienced forced displacement. Plaintiff alleges that, because Gray used the authority and threats associated with his code enforcement position to pressure plaintiff's housing providers as described herein, the resulting displacement functioned as a constructive eviction carried out without the procedural protections ordinarily required before termination of a lawful tenancy, depriving plaintiff of residential stability and property interests. 5. After plaintiff was told to leave, the landlord, acting under the influence of defendant Gray's complaints, refused to allow plaintiff to return to the residence to continue living there. Although no lawful eviction process had occurred, the landlord made clear that plaintiff was no longer permitted on the premises. Because law enforcement had historically accepted and acted on Gray's statements in prior unrelated interactions, plaintiff reasonably feared that returning to the residence would result in confrontation or police involvement. This effectively prevented plaintiff from accessing a home he was legally entitled to occupy, causing forced displacement and substantial loss. 6. Plaintiff was not provided any formal eviction process, paperwork, or hearing in connection with the removals described above and was forced into sudden displacement. Plaintiff sustained damage to personal items, lost work due to the forced relocation, incurred financial strain from emergency relocation, and suffered emotional distress associated with the abrupt loss of housing stability and personal security. 7. At all relevant times, Chad Gray acted under color of law by using and leveraging his position as a code enforcement official, and the apparent authority of that office, to pressure plaintiff's landlords and threaten adverse governmental action, including threatening to obtain a warrant to have plaintiff's bus removed during the Willix Lane period. 8. Plaintiff alleges that Gray's housing interference overlapped in time with the onset of harassment by defendants Thayer and Archbell, and, on information and belief, based on later public statements and admissions by Thayer regarding an ongoing relationship with defendant Arod, these actions were part of a broader, connected course of conduct described elsewhere in this complaint. Count 2 Actions of defendants David Archbell and Robert Thayer. Plaintiff incorporates all factual statements, stated above and below. 9. After plaintiff sought legal relief by filing suit in 2022, regarding the unlawful removal from his residence, defendants David Archbell and Robert Thayer initiated a sustained pattern of confrontation, intimidation, and targeted harassment directed at plaintiff. As documented in Affidavit 2, both men confronted plaintiff in a shopping center parking lot while visibly armed. They approached plaintiff in a hostile manner, engaged him verbally, recorded the encounter, and later published the video online accompanied by false and misleading statements portraying plaintiff as dangerous or unstable. 10. The videos posted by defendants over the last 3-year time span drew negative public attention and resulted in hostile reactions from viewers who accepted defendants' false statements as true. Plaintiff experienced fear for his safety due to indirect threats and comments arising from the video's circulation. Plaintiff promptly reported the incident to law enforcement and provided officers with the video as direct evidence of the confrontation. Despite the presence of armed individuals, online publication of defamatory content, and plaintiff's detailed report, authorities did not perform a meaningful investigation or provide any protective response. 11 Shortly after the first incident, defendant Arch Bell again confronted plaintiff while visibly armed, this time inside a King Soopers grocery store, as documented in Affidavit 3. Arch Bell followed plaintiff through the store, recorded plaintiff at close range, and attempted to provoke a reaction. He later posted the footage online with commentary designed to mischaracterize plaintiff's behavior and further harm plaintiff's reputation. These actions occurred in the presence of customers and store employees. Plaintiff formally reported this second armed encounter to law enforcement, yet law enforcement did not perform a meaningful investigation or provide any protective response. 12 From 2022 through 2025, defendants Arch Bell and Thayer continued to engage in repeated acts of monitoring and harassment. They appeared at public locations where plaintiff was present, followed plaintiff during routine activities, and posted images and statements about plaintiff online. This activity extended to plaintiff's residence, including a live broadcast and recorded drive-by of plaintiff's home in which defendants discussed violent acts, including where to dispose of a body, and referenced weapons and related tactical assets, and which, when viewed together with defendants' other published videos depicting firearms, target practice, and gear such as a sniper-style rifle, ghillie suit, waders, and a drone, reasonably heightened plaintiff's fear for his safety, including fear of unobserved off-camera conduct. Their conduct created continuous fear, humiliation, and instability. As a result of defendants' persistent actions, plaintiff was forced to alter routines, limit public activity, and remain in a heightened state of vigilance due to the ongoing, unpredictable nature of their behavior. Arch Bell and Thayer invoked or implied ties to law enforcement or county officials in ways that discouraged calls for intervention. Count 3 Actions and omissions of law enforcement, Larimer County and Fort Collins Police. Plaintiff incorporates all factual statements, stated above and below. 13 Throughout these events, plaintiff repeatedly reported incidents involving defendants Arch Bell and Thayer to both the Fort Collins Police Department and the Larimer County Sheriff's Office. Plaintiff provided specific dates, locations, descriptions of conduct, and, in several instances, direct video evidence documenting the confrontations, surveillance, and online postings. 14 Despite plaintiff providing officers with detailed information and, in some instances, offering video evidence of the confrontations, law enforcement did not conduct any meaningful investigation. Officers did not follow up with plaintiff, did not contact the individuals involved, and did not take steps to evaluate or address the ongoing pattern of harassment. In multiple reports, officers concluded the situations were civil or otherwise declined action without reviewing available evidence, leaving plaintiff without protection despite repeated requests for assistance. 15 This pattern of refusal by law enforcement to take action or to document plaintiff's reports enabled the continued conduct of defendants Arch Bell and Thayer. Their ongoing surveillance, repeated approaches, and continued recording of plaintiff occurred without any deterrence or consequence, increasing plaintiff's fear and leaving plaintiff without protective assistance from local authorities. 16 Law enforcement's repeated failure to respond, or to meaningfully investigate, or document plaintiff's reports, despite clear warnings that the conduct was escalating, left plaintiff without protection and vulnerable to continuing harassment. As the incidents continued and intensified, plaintiff was left with no reliable means of securing safety and was compelled to shelter in place and remain inside, in an effort to avoid further contact with defendants Arch Bell and Thayer. 17 The demonstrated unwillingness of police to intervene, even after incidents involving weapons, threats, and repeated confrontations, caused plaintiff to experience increasing fear, anxiety, and hypervigilance. Plaintiff reasonably believed that calling law enforcement would not result in assistance and might expose plaintiff to additional risk, further compounding the emotional harm and instability caused by the ongoing harassment. These repeated failures reflect a broader policy or custom of disregarding credible citizen reports of harassment and retaliation, rendering both agencies liable under Monell. 18 In multiple contacts with Fort Collins Police and the Larimer County Sheriff's Office, plaintiff specifically requested that officers, a. review the available video evidence, b. contact defendants Arch Bell and Thayer, and c. document the pattern of escalating conduct as a connected series of events rather than isolated civil disputes. 19 Plaintiff also requested basic protective steps, including issuance of warnings, documentation of no-contact concerns, and guidance on lawful protective options. Plaintiff was not provided meaningful protective assistance, and the agency's responses did not reflect review of the pattern, the use of weapons, or the intimidation aspect of the encounters. 20 Plaintiff observed that reports involving the same individuals were not handled consistently, and that the responses repeatedly minimized the conduct despite plaintiff's repeated notice that the conduct was escalating, that confrontations were occurring in public places, and that online publication increased the risk of third-party hostility. 21. The non-response and minimization by law enforcement operated as a de facto signal to the perpetrators that their conduct would not lead to enforcement consequences, and it materially increased plaintiff's vulnerability by leaving plaintiff without ordinary protective intervention despite repeated notice and provided evidence. 22. Plaintiff alleges that the failures described in this count were not a single mistake but repeated non-enforcement decisions made after notice, contributing to the continuation and escalation of the harassment, surveillance, and intimidation described above, and supporting plaintiff's Monell allegations in count 9. Count 4. Actions of Deputy County Attorney David Arad. Plaintiff incorporates all factual statements, stated above and below. 23. Deputy County Attorney David Arad is an attorney in the Larimer County Attorney's Office. Plaintiff previously brought a federal action arising from related events in 2022, Frederickson v. Larimer County, Case No. 22 CV 00262 CMA, D. Colorado, and plaintiff alleges on information and belief that Arad appeared and/or served as counsel on behalf of Larimer County and/or county officials in that matter. Plaintiff alleges that Arad's involvement in plaintiff's matters later continued into plaintiff's 2025 efforts to pursue protection order relief and related communications, as further described below. 24. In 2025, plaintiff pursued related filings in Larimer County arising from the ongoing harassment described in this complaint. Plaintiff alleges that, in connection with those filings and plaintiff's county-level communications about related procedures and processing, Deputy County Attorney David Arad became the county official through whom plaintiff's communications were routed and addressed. 25. Plaintiff alleges that Deputy County Attorney David Arad's continued role as the county's point of contact and legal responder created a non-neutral conflict and gatekeeping problem after defendant Thayer publicly invoked Arad by name in connection with alleged county contracts and their extension through 2030. Plaintiff alleges that, despite this public linkage, Arad continued responding on behalf of Larimer County and communicating through county channels about plaintiff's complaints and evidence, including by issuing denials regarding any county contracts with Thayer and Arch Bell, while county offices and staff routed plaintiff's inquiries and communications back through Arad rather than a neutral, unconflicted county contact. 26. Plaintiff alleges that, despite that conflict, Arad did not withdraw or recuse and instead continued acting on the county's behalf in matters connected to plaintiff's efforts and related case activity. 27. Plaintiff alleges that Arad's continued participation operated as a non-neutral barrier because plaintiff's efforts to obtain routine procedural assistance and access ordinary county channels became subject to control by the same official publicly invoked by defendant Thayer in connection with alleged county contracts, while county offices and staff routed plaintiff's inquiries and communications back through Arad rather than a neutral, unconflicted county contact. 28. The specific routing directive, resulting communications bottleneck, and the procedural obstruction and deterrence that followed are alleged in detail in Count 5 and are supported by contemporaneous written communications in plaintiff's possession. Count 5. Court access interference/procedural obstruction, Deputy County Attorney David Arad. Plaintiff incorporates all factual statements, stated above and below. 29. As set forth in Count 4, plaintiff alleges that Deputy County Attorney David Arad's conflict of interest and continued participation affected plaintiff's access to ordinary, neutral county processes necessary to pursue protective relief and related court remedies. 30. Plaintiff alleges that, after defendant Thayer publicly invoked Arad by name and plaintiff raised related concerns through county channels, county administrative channels plaintiff would ordinarily use for routine procedural questions and case-related communication stopped functioning normally. Instead, plaintiff's inquiries were redirected, delayed, or treated as matters that could not be addressed through ordinary channels. 31. Plaintiff alleges that Larimer County administration confirmed that, at Arad's direction, plaintiff's communications and inquiries were to be routed to Arad. Plaintiff alleges that this directive required plaintiff to direct routine procedural questions, concerns, and notices to the same official whose conduct plaintiff had placed at issue, thereby eliminating neutral access and creating a non-neutral gatekeeping pathway. 32. Plaintiff alleges that the routing directive and resulting gatekeeping caused delay, confusion, and inconsistent responses, and it interfered with plaintiff's ability to obtain timely procedural information and to pursue protective relief through ordinary processes. Plaintiff's allegations regarding the routing directive and its effects are supported by contemporaneous written communications in plaintiff's possession. 33. Plaintiff alleges that these barriers materially deterred plaintiff from using ordinary processes to pursue protection and contributed to delay in pursuing protection order relief, leaving plaintiff exposed to continued harassment during the period in which plaintiff was hindered in pursuing court remedies. 34. Plaintiff reasonably believed that continuing to pursue legal protection would result in further retaliation or adverse action by officials, particularly in light of the harassment plaintiff alleges began in 2022 involving defendant Thayer and the October 20, 2025 incident in which plaintiff received a criminal citation immediately following plaintiff's attempt to lawfully serve defendant Thayer with court documents. 35 Because of these experiences, plaintiff hesitated to submit additional filings, make routine inquiries, or continue seeking certain forms of protective relief. Plaintiff alleges that the diversion of communications and the surrounding circumstances deterred plaintiff from using ordinary court-related processes and materially limited plaintiff's ability to pursue timely and effective judicial protection. 36 Plaintiff's right of access to the courts was substantially chilled, and plaintiff suffered ongoing emotional distress, uncertainty, and instability due to the interference with ordinary processes and the reasonable fear that further attempts to assert legal rights would provoke further retaliation. Plaintiff alleges actual injury, including delay in pursuing protection order relief and increased exposure to continued harassment during the period in which plaintiff was deterred from, or hindered in, pursuing court remedies. 37 These acts violated plaintiff's First Amendment right to petition the government and plaintiff's 14th Amendment right of access to the courts. Count 6 Retaliatory citation/retaliatory policing, October 20, 2025. Plaintiff incorporates all factual statements, stated above and below. 38 On October 20, 2025, after a court hearing where defendant Thayer was present, plaintiff attempted to lawfully serve Thayer with process outside the courthouse. 39 On October 20, 2025, plaintiff appeared for a court hearing initiated by defendant Thayer. After the hearing, plaintiff exited the courthouse and proceeded to attempt lawful service of process related to that court matter. 40 When plaintiff exited the courthouse, defendant Thayer was waiting in the courthouse parking lot, camera in hand recording. Thayer had positioned himself there in advance and initiated contact by taunting plaintiff, gesturing toward him, and motioning for plaintiff to approach or follow him. These actions were consistent with the prior pattern of provocation and unsafe behavior described in earlier affidavits. 41 Plaintiff followed Thayer only for the purpose of completing lawful service of process stemming directly from the court proceeding Thayer had initiated. Plaintiff's conduct was limited to carrying out the procedural requirement of service and did not involve threats, aggression, or any conduct prohibited by law. 42 Because of prior confrontations involving Thayer and Arch Bell, plaintiff notified Fort Collins Police in advance and requested an officer standby during plaintiff's attempt to complete lawful service of process. Plaintiff alleges that officers refused to provide standby or assistance and later refused to allow plaintiff's third-party process server to complete service at the police station, resulting in service not being completed on October 20, 2025. 43 Plaintiff alleges that, within a short time after October 20, 2025, plaintiff completed service by email and that service was treated as valid. Plaintiff alleges that days after service was completed, Fort Collins Police directed plaintiff to come to the police station and issued plaintiff a criminal harassment citation arising from the same sequence of events. The citation charged plaintiff with harassment C.R.S. 18-9-111-1, as identified on the citation. 44 Plaintiff alleges the citation was issued without probable cause and without meaningful inquiry into the court-related context or the legality of plaintiff's service-related conduct. Plaintiff alleges officers did not evaluate whether plaintiff's actions were undertaken solely to complete service of process tied to the courthouse proceeding, did not assess the limited and service-focused nature of plaintiff's conduct, and did not consider the absence of threats, repeated unwanted contact, or other facts typically associated with criminal harassment. 45 Plaintiff alleges Fort Collins Police converted plaintiff's service-related conduct into a criminal harassment allegation by characterizing plaintiff's attempt to complete lawful service of process as following Thayer, while declining to account for Thayer's provocation, the court process context, and plaintiff's prior reports documenting the ongoing pattern. Plaintiff alleges the timing and circumstances support an inference that the enforcement decision was retaliatory and or selectively applied. 46 The retaliatory citation caused plaintiff significant emotional distress, renewed fear of further retaliation, and hesitation in continuing court proceedings. Plaintiff experienced disruption of ongoing legal matters and increased concern that any future attempt to enforce legal rights or pursue filings could result in similar punitive action by law enforcement. The citation lacked probable cause because service of process is a lawful act and cannot constitute harassment under Colorado law. Count 7 Damages/ongoing injury. Plaintiff incorporates all factual statements, stated above and below. 47 As a direct result of defendant's conduct, plaintiff lost stable housing and was forced to relocate multiple times due to harassment, surveillance, and resulting instability. Plaintiff also lost personal property during the 2022 removal and incurred emergency housing and relocation expenses, causing ongoing financial disruption. 48 Plaintiff suffered severe emotional distress, including fear, humiliation, anxiety, hypervigilance, and chronic sleep disruption, caused by the repeated confrontations, ongoing surveillance, and law enforcement's refusal to meaningfully investigate or provide protection despite repeated reports. 49. The prolonged stress, fear, and instability caused by defendant's actions contributed to significant physical deterioration documented in plaintiff's medical records, including impaired ability to rest, maintain stability, and consistently follow medical recommendations. 50. In 2024, plaintiff underwent coronary bypass surgery. Treating physicians confirmed that prolonged psychological distress, ongoing instability in living conditions, and plaintiff's smoking history were contributing factors to plaintiff's cardiac condition. 51. Plaintiff's recovery and follow-up care were impeded by continued harassment, unstable and unsafe living conditions, and ongoing fear for personal safety, which disrupted rest, continuity of care, and adherence to medical recommendations. 52. Plaintiff suffered substantial economic harm, including repeated relocation costs, costs to replace property lost or damaged during the 2022 displacement, and lost work and income opportunities resulting from ongoing surveillance, unwanted contact, and instability. 53. Plaintiff's ability to access courts and pursue relief was materially interfered with by intimidation from defendants Archbell and Thayer, the October 20, 2025 retaliatory citation by Fort Collins Police, and the gatekeeping and deterrent effects of defendant Arod's continued involvement and routing of plaintiff's communications. These combined actions caused plaintiff to reasonably fear further retaliation and delayed or deterred plaintiff from filings and court-related activity. 54. These financial, emotional, and physical harms were foreseeable consequences of defendant's conduct. Plaintiff repeatedly notified law enforcement and county officials that the conduct was escalating and causing harm, yet officials failed to take meaningful protective or investigative action, enabling continued targeting and increasing plaintiff's injuries. 55. These harms are ongoing. Plaintiff continues to experience fear for personal safety, financial instability from displacement and loss of property, disrupted medical stability, and continuing obstacles and deterrence when attempting to seek legal protection or engage court processes. Count 8 Civil RICO, 18 U.S.C. 1962, c. Plaintiff incorporates all factual statements stated in counts 1 to 7 as if fully set forth herein. 56 Plaintiff alleges that defendants Chad Gray, Robert Thayer, David Archbell, and David Arod, together with other persons known and unknown, formed and or associated with an enterprise within the meaning of 18 U.S.C. 1961, 4, including an association in fact enterprise, for the common purpose of harassing, intimidating, discrediting, obstructing legal relief, and destabilizing plaintiff's housing, safety, and ability to pursue lawful remedies. 57. Plaintiff alleges the enterprise operated through repeated and mutually reinforcing conduct over multiple years, including misuse of apparent governmental authority to pressure plaintiff's landlords and disrupt housing. Armed confrontations, surveillance, recording, and publication targeting plaintiff, online targeting intended to shame and intimidate and increase third-party hostility, administrative gatekeeping and procedural obstruction affecting plaintiff's ability to pursue protective relief and ordinary court processes, and retaliatory enforcement action arising from plaintiff's court-related conduct and efforts to complete lawful service of process, all as alleged in counts 1 to 6. 58 Plaintiff alleges defendants conducted and or participated, directly or indirectly, in the enterprise's affairs within the meaning of 18 U.S.C. 1962, c. by committing and facilitating acts that furthered the shared purpose and by amplifying the impact through asserted official authority, county channels, and repeated online publication. 59 Plaintiff alleges the enterprise's activities affected interstate commerce through, among other means, the use of electronic communications, online platforms, and dissemination of content directed at plaintiff and the public. 60 Plaintiff alleges a pattern of racketeering activity within the meaning of 18 U.S.C. 1961, 5, consisting of multiple related acts over time directed at the same victim, using recurring methods and escalation, and posing a threat of continued similar activity, as shown by the continuity of conduct alleged from at least 2020 through 2025 and thereafter. 61. The pattern includes racketeering predicate acts supported by the conduct, publications, reports, and official communications described in counts 1 to 7, including extortion and or attempted extortion through threats and fear, 18 U.S.C. 1951, intimidation intended to hinder, delay, prevent, or dissuade plaintiff from pursuing or participating in litigation and related official proceedings, including reporting, filing, and service of process activity, 18 U.S.C. 1512. B. Retaliation for pursuing legal relief and participating in legal process, including escalation tied to plaintiff's court activity and efforts to obtain protective relief, 18 U.S.C. 1513, E. And use of interstate electronic communications to disseminate materially false representations about plaintiff and or defendant's asserted authority or backing in furtherance of the intimidation discrediting scheme and related monetization or solicitation activity alleged herein, 18 U.S.C. 1343. 62 Plaintiff alleges the enterprise conduct was not isolated or accidental but coordinated in timing and function, including role splitting and escalation, housing pressure and destabilization, armed confrontations and publication, administrative gatekeeping affecting court access, and enforcement action following plaintiff's protected court-related activity supporting the inference of a shared purpose and coordinated action. 63 As a direct and proximate result of defendants' violations of 18 U.S.C. 1962, c. Plaintiff suffered injury to business and property, including loss of and damage to personal property, out-of-pocket relocation and emergency housing costs, lost work and lost income opportunities, and other quantifiable losses alleged in counts 1 to 7, which flowed from the enterprise's intimidation, obstruction, retaliation, and destabilization. 64 Plaintiff seeks relief available under 18 U.S.C. 1964, c., including treble damages, costs, and such other relief as the court deems proper. Count 9 Mon-El liability/policy, custom/failure to train, supervise, discipline, City of Fort Collins and Larimer County. Plaintiff incorporates all factual statements previously stated, including counts 1 to 8, as if fully set forth herein. 65 Defendant City of Fort Collins, Colorado is a municipal corporation organized under Colorado law, with principal offices at 300 LaPorte Avenue, Fort Collins, Colorado 80521, and is liable under Mon-El for constitutional violations caused by official policies, customs, practices, and failures to train, supervise, or discipline within Fort Collins Police Services. 66 Defendant Larimer County, Colorado is a political subdivision of the state of Colorado, with principal offices at 200 West Oak Street, Fort Collins, Colorado 80521, and is liable under Mon-El for constitutional violations caused by official policies, customs, practices, and failures to train, supervise, or discipline within county departments, including the Larimer County Sheriff's Office. 67 Defendant Chief Jeff Swoboda, Chief of Police for Fort Collins Police Services, is sued in his official capacity for prospective declaratory and injunctive relief addressing FCPS policies, practices, training, and supervision. FCPS Headquarters, 2221 South Timberline Road, Fort Collins, Colorado 80525. 68 Defendant John J. Fayen, Larimer County Sheriff, is sued in his official capacity for prospective declaratory and injunctive relief addressing Sheriff's Office policies, practices, training, and supervision. Sheriff's Office Administration, 2501 Midpoint Drive, Fort Collins, Colorado 80525. 69 Defendant Janine S. Hogg, Larimer County Attorney, is sued in her official capacity for prospective declaratory and injunctive relief to the extent County Attorney's Office directives or practices affected plaintiff's access to neutral county processes and court-related channels as alleged herein. Office address, 224 Canyon Avenue, Suite 200, Fort Collins, Colorado 80521. 70. Plaintiff alleges the constitutional injuries described in counts 1 to 7 were caused, enabled, prolonged, and/or ratified by municipal policies, customs, and practices of the City of Fort Collins and Larimer County, including a pattern of declining to investigate or respond meaningfully to repeated reports of harassment, intimidation, and retaliation, misclassifying escalating conduct as civil without meaningful review, failing to accept, review, preserve, or act upon offered video evidence, and permitting repeated non-enforcement decisions that signaled continued targeting would occur without consequence. 71 Plaintiff further alleges inadequate training, supervision, and discipline regarding recognition and handling of repeated harassment/intimidation reports, review and preservation of offered video evidence, documenting patterns of conduct across incidents rather than treating each report as isolated, and preventing retaliatory enforcement actions following protected court-related activity. After repeated notice and escalation warnings, continued inaction reflected deliberate indifference to an obvious risk of constitutional injury. 72 As alleged in counts 2 to 3 and 6, plaintiff repeatedly reported incidents involving Thayer and Archbell to FCPS and LCSO and provided dates, locations, and video evidence, yet officials repeatedly declined meaningful investigation, follow-up, or basic protective or documentation steps. 73 Plaintiff alleges these policies, customs, and failures were the moving force behind the continued escalation and deprivation of plaintiff's rights, including the continuation of harassment, counts 2 to 3, the chilling and obstruction effects, counts 5 to 6, and the injuries, count 7, culminating in enforcement action against plaintiff arising from court-related conduct while plaintiff's reports concerning the opposing parties were repeatedly minimized or disregarded. 74 Plaintiff alleges Chief Swoboda and Sheriff Fayen, in their official capacities, were responsible for implementation, training, supervision, and oversight that resulted in the customs and practices described above, and that prospective declaratory and injunctive relief is necessary to prevent continuation of unconstitutional practices. 75 as a direct and proximate result of the City of Fort Collins and Larimer County's policies, customs, practices, and deliberate indifference described above, plaintiff suffered the injuries described in Count 7, including loss of housing stability, out-of-pocket losses, loss or damage to property, emotional distress, fear, and continuing impairment of plaintiff's ability to obtain meaningful protection through ordinary channels. Count 10 Equal protection, selective enforcement/disparate treatment, 42 U.S.C. 1983. Plaintiff incorporates the factual allegations in counts 3 and 6 as if fully set forth herein. 76 Plaintiff alleges Fort Collins police intentionally treated plaintiff differently from a similarly situated individual, defendant Robert Thayer, during the same continuing dispute described in this complaint. Over an extended period, plaintiff reported Thayer's and Archbell's confrontations, intimidation, surveillance, and harassment-type conduct, providing dates, locations, and supporting information, including publicly posted recordings created by Thayer and Archbell. Despite notice and repeated requests for enforcement and protection, officers repeatedly declined meaningful investigation or protective action regarding Thayer's and Archbell's conduct. Plaintiff alleges Thayer and Archbell initiated the reported encounters and plaintiff did not. 77 Plaintiff alleges that on October 20, 2025, Thayer appeared for a court hearing while not yet served, and plaintiff understood service was required for the protection order process to proceed. After the hearing, Thayer remained in the courthouse parking lot recording and signaling plaintiff to follow. Plaintiff attempted lawful service of process and requested police standby due to prior confrontations, but police refused standby and refused to allow plaintiff's third-party server to complete service at the police station, so service was not completed that day. Plaintiff later completed service by email, which was treated as valid. Plaintiff alleges that days after service was completed, Fort Collins police directed plaintiff to the station and issued a criminal harassment citation arising from the same events. 78 Plaintiff alleges plaintiff and Thayer were similarly situated for enforcement purposes because the dispute involved the same parties and history known to officers, and plaintiff had repeatedly sought enforcement and protection regarding Thayer's conduct. Plaintiff alleges there was no rational, non-retaliatory basis to decline action on plaintiff's reports against Thayer and Archbell over time while initiating enforcement against plaintiff based on plaintiff's court process conduct. Plaintiff alleges this disparity supports an inference of arbitrary, hostile, and/or retaliatory enforcement tied to plaintiff's protected court-related activity. 79 On information and belief, plaintiff alleges Thayer's and Archbell's public recordings and publications were intended to intimidate and discredit plaintiff and to encourage third-party hostility, including in connection with solicitation of support or donations through online platforms. In contrast to the repeated non-response to plaintiff's reports about Thayer and Archbell, plaintiff was cited, causing injury including a criminal citation, increased burden and disruption to plaintiff's legal efforts, and a chilling effect on plaintiff's continued attempts to seek court protection and petition the government. Plaintiff alleges these injuries were proximately caused by unequal enforcement and disparate treatment of similarly situated parties. Count 11 Retaliation/obstruction of official processes and interference with court access, actual injury from intimidation. Plaintiff incorporates all factual statements previously stated, including counts 1 to 10, as if fully set forth herein. 80 Plaintiff engaged in protected activity by pursuing and participating in civil litigation and related court process, including a. Federal civil litigation in Illinois, Fredrickson v. Landeros, Case No. 11 CV 03484, and related appeal, No. 18-1605, and b. Federal civil litigation in Colorado, including Fredrickson v. Larimer County, Case No. 22 CV 00262 CMA, D. Colorado, as well as court access and protection order efforts described elsewhere in this complaint. 81 After relocating to Colorado, defendant Chad Gray, acting under color of law as alleged in Count 1, used the apparent authority and threatened enforcement consequences associated with his code enforcement position to pressure plaintiffs' housing providers and destabilize plaintiffs' housing, causing displacement and emergency relocation burdens as alleged in Count 1, and materially impairing plaintiffs' ability to maintain steady employment and the stability necessary to litigate. 82 Plaintiff alleges that Gray's housing interference substantially contributed to plaintiff accepting a settlement in the Illinois matter under conditions of severe attrition and diminished capacity, constituting litigation-related injury and economic harm proximately caused by Gray's conduct described in Count 1. 83. Plaintiff further alleges that after plaintiff pursued legal relief in Colorado in 2022, defendants Robert Thayer and David Archbell escalated intimidation, harassment, surveillance, and online publication as alleged in Count 2 and reflected in the referenced affidavits, including public references to plaintiff's Colorado lawsuit and implied or claimed county support or backing, which plaintiff alleges was intended to deter plaintiff from continuing litigation activity and to convey that official accountability or protection would not be available. Plaintiff reported these matters to law enforcement as alleged in Count 3 without meaningful investigation or protective response. 84 Plaintiff alleges that defendant David Arad, acting under color of law as alleged in counts 4 to 5, became the county official through whom plaintiff's litigation-related communications and procedural inquiries were routed and addressed, and that the routing directive and resulting gatekeeping materially interfered with plaintiff's access to ordinary, neutral processes for pursuing protective relief and related court remedies as alleged in counts 4 to 5. 85 Plaintiff alleges that the combined course of conduct by defendants Gray, Thayer, Archbell, and Arad together with the municipal non-response and minimization alleged in count 3 and the retaliatory citation alleged in count 6 operated to deter, obstruct, and chill plaintiff's ability to pursue litigation and court process. 86 Plaintiff alleges actual injury resulting from this retaliation and interference, including that in the 2022 Colorado federal action, Frederickson v. Larimer County, Case No. 22 CV00262 CMA, plaintiff missed a litigation deadline to file required court papers, was thereafter unable to continue prosecuting the action, and ultimately discontinued or abandoned it. Plaintiff alleges the missed deadline and loss of that action were caused by the intimidation, housing instability, fear for personal safety, and deterrent gatekeeping and retaliatory enforcement described in counts 1 to 6. 87. Plaintiff alleges the adverse actions described herein would chill a person of ordinary firmness from continuing to pursue court remedies. That plaintiff's protected litigation activity was a substantial or motivating factor for the adverse actions alleged, and that, as a direct and proximate result, plaintiff suffered damages including litigation-related injury, economic harm, lost work and income opportunities, increased out-of-pocket costs tied to displacement and instability, and the emotional and physical harms described in count 7. These acts violated plaintiff's First Amendment right to petition and to be free from retaliation for protected activity, and plaintiff's 14th Amendment right of meaningful access to the courts.